by deleting the allegations of protected activity in the original complaint. The case law is clear
why is that such a problem, Mr. Finberg, given that if they deleted those allegations, they could no longer impose any liability based on them? Wouldn't that have served the purpose of the SLAPP statute?
Well, Justice Stewart, it's important for several reasons. The point of the statute is not to burden a person or entity who is engaged in protected activity, which the city did here by, among other things, defending itself in the federal court lawsuit, both in the trial and on appeal, by bringing the original complaint that had allegations of protected activity, including the city having defended itself in the federal court, in the trial court, and on appeal. The city had to go to the burden and expense of challenging the allegations in that complaint. And there are many other allegations of protected activity in that complaint involving briefs to the Surface Transportation Board and public statements, letters by the mayor to the Alameda County Transit Board. And the city shouldn't have had to defend itself against that protected activity to the extent that it prevails on the anti-SLAPP motion directed at the original complaint. It will be entitled to attorney's fees for having to have undergone that burden. And going forward, it is important to have clarity as to whether protected activity is or is not going to be in this case. Oakland shouldn't have to go through the burden of having to file another motion directed at a complaint that has protected activity, and it shouldn't have to respond to broad discovery requests directed at improper allegations. So at a minimum...
Well, I guess the way it's now postured, you won't have to do that because there won't be an attack on the next complaint, because you've chosen to attack this one, asking us to decide it on the merits.
Justice Richmond, we would like this court to exercise its discretion to rule as to the anti-SLAPP motion as to the original complaint, and to clarify that the allegations of protected activity in that complaint, including having defended itself in the federal lawsuit, having made public statements about coal, having filed briefs before the Surface Transportation Board, having sent a letter to the ACTC, shouldn't be the subjects of litigation in state court. And
well, if you're going to go there, Mr. Finberg, and I'm fine with it, but isn't the heart of what the case is about is the city breaching a contract with the Oakland bulk and oversized terminal, and I think there's a co-defendant, but or a co-plaintiff, but and not, you know, how much of this stuff that you're talking about, these statements, is really key to the causes of action as opposed to, or to the gist of the claim, as opposed to sort of evidence that supports the allegations of breach?
Your Honor, in Burrell versus Schmidt, the California Supreme Court set forth the standard that an anti-SLAPP motion is appropriate when allegations of protected activity are asserted as grounds for relief. And when they are, it's not merely incidental, and it's not merely evidence to the main claim. So let me turn the Justice's attention to paragraph 156 of the first cause of action in the original complaint, which is volume 1, document 1, page 7 of the record. Paragraph 156 says the city breached the lease and DA by, among other things. And then it gives a whole list of things that are independent breaches of the contracts. And that satisfies the Burrell standard, that these are asserted grounds for relief because they are asserted as each independent breaches of these contracts. And in that list, they have assertion of a defense of the illegal ordinance and resolution in the trial court and prosecution of an appeal. Allegation that OBOT committed an unmatured event of default. So when the city gave a notice of default, they're alleging that that is a breach of contract. In the Feldman case, the Court of Appeals.
Mr. Finberg, well, you mentioned the Feldman case. I must say, I find it surprising that you guys rely so heavily on Feldman, in that Feldman's been criticized, including by our own division. I mean, that's the early Division II case. If you go read Weil and Brown, they will say that Feldman is unsupportable at this point. And I said the same thing in Moriarty, but that's kind of a different issue. I want to get back to what you said at the beginning, because for purposes of discussion, let's say you're absolutely right about protected activity in defending the lawsuit. The fact is that if you hadn't appealed, you would have gotten the first amended complaint, and you guys rely on that first amended complaint by what isn't in it. And I must say, I find that a little bit inappropriate, because it was your appeal that didn't allow the first amended complaint to be filed. That said, apparently they were going to take out the defense of the lawsuit. And that, people have issues with Burrell. It says what it says. Lots of personal discussions with Justice Corrigan, who wrote it, because it raises interesting issues down the road as to what you can do with the stricken facts. But the case goes on, right? And this case was always going to go on. Everybody knew that. The original motion filed by your predecessors said it's moving in part. Your brief acknowledges that there's unprotected activity. And Judge Lee, I thought, as best I could tell with her experience and wisdom, the way she dealt with this was about as efficient and appropriate for a trial court as is, to me, humanly possible. Because at the argument on the demur, I mean, let's face it, the SLAPP motion was weeks before it was set to be heard, right? And Judge Lee brought it up early in the demur hearing on the 25th of April. And she's the one who said, I think it's premature, basically. And then the plaintiff's lawyer, I think it was Mr. Lee, I forgot who was arguing there, said, Your Honor, let's set a trial date. And you personally stood up. You didn't argue. It was your colleague, I've forgotten her name, who did all the argument on the demur and what I call the standard motion to strike. And you said, that's not a good idea, Your Honor, because what's going to happen is they're going to file an amended complaint and we'll file another motion. That's what you said. And had that happened, you probably would have had stricken the one or two things that perhaps are properly stricken. And my guess is you would have gotten some attorney fees for that. I guess that we don't know, because you all chose not to wait and see the amended complaint, and you filed the appeal. And I have to ask you, because as I sit here, I mean, Mr. Schatz knows this. I'm on record as being concerned about inappropriate appeals in SLAPP cases. I think his office was the brunt of one of my criticisms. What is the motivation for having filed this appeal?
Your Honor, the motivation is to get clarity as to whether these allegations of protected activity that were in the original complaint are going to be out of the complaint, so that the city does not need to make another motion directed at those allegations, and the city does not have to respond to discovery regarding allegations of protected activity. In cases like Salma and Seiler have made clear that the court shouldn't allow amendment. The court should rule on a SLAPP motion directed at the original complaint. The proposed amended complaint has never been filed. We don't know if that's the complaint that OBOT will end up filing, or whether they will file something that has a lot of the protected activity that was included in the original complaint. And if they do, the city would have to demur again and move to strike under anti-SLAPP at those incidents of protected activity. So it's to meet the purposes of the statute, to alleviate the burden to have to defend a lawsuit and answer discovery regarding allegations that are protected activity for which the plaintiff cannot meet its burden on the claims.
I guess I didn't get an answer to the question about what's the motivation for this, because had you awaited the amended complaint, which the plaintiff's lawyer said is going to come fast, you would have known what was in there and what was out, and therefore what you had to defend against. And that would have solved part of the problem. I must tell you, for the reasons I'm on record on at least 2 or 3 cases, I'm concerned that these appeals are nothing but delay.
Well, Justice Richmond, to give you 2 direct answers. One is the city was entitled to attorney's fees for having prevailed on a meritorious anti-SLAPP motion directed at the first complaint. That's reason 1. And 2.
My point is you would have gotten those had you awaited, I believe, the first amended complaint. I mean, nobody knows that, but it seems to me if I'm the trial judge and I get an amended complaint that has eliminated 2 or 3 things that I've attacked before, and I'm the judge and I've said it's premature, you'll win some attorney fees for that. I think that's how it would work.
Well, Justice Richmond, it's a little unclear because we would not have been the prevailing party on the anti-SLAPP motion because the trial judge denied the anti-SLAPP motion. So it's not clear that we had standing
this as premature.
And there are also, although the proposed First Amendment complaint certainly eliminates a lot of the protected activity that was in the original complaint, there are still some allegations having to do with the STB and permitting that suggest that it is still directed at some briefing and public statements that the city made in connection with official proceedings. So even the proposed amended complaint, I think, is not as clean as the complaint could be. And that's one of the reasons that we're here, to ask this court to clarify that these other allegations in paragraph 156, there's defending.
You want to focus on 156. Let's focus on the 237 paragraphs in the complaint and the 135 paragraphs of charging allegations. I mean, you're stuck with what your predecessors filed, right? There's no question about that. De novo review, that's what's before us, right? They don't even say which of the 4 parts of subdivision E they're even relying on.
Well, Your Honor, I'd be happy to address that. And in addition to paragraph...
Anyway, we don't have to go there, but they don't even say what it is. So they take a complaint that's, I forget now how many pages it is, it's 65 pages or something, with all those paragraphs, and they file a 20-page motion. The first 5 pages are the table of contents and authorities. The next 3 pages are boilerplate, SLAPP stuff. And then they say in 5 lines, this is what the complaint is about. And they say it's 7 things and 6 of them are protected activity. You know what I'm talking about. And then they spend 4 pages total trying to argue why it is that those 6 things are what this complaint is about. They mention nothing about any of the tort claims. They mention nothing about the breach of the covenant of good faith and fair dealing. They just say, this is what it's about, and here's the arguments. And the 6 arguments, you can go look for yourself. 1 of them is 1 paragraph. 2 of them are 2 paragraphs. And that's the record that we have here before us. So I guess you're going to have to convince us, or at least me, but us, why it is that this is based on protected activity.
Well, Justice Richmond, in addition to paragraph 156, which was the breach of contract claim for relief, paragraph 168, which is the implied covenant of good faith cause of action, again, has a list of separate and independent breaches. And again, that list contains many examples of protected activity, including defending the federal lawsuit, including giving a notice of default, including statements about permits, including statements before the ACTC, including statements before the STB, and including private and public statements by elected officials opposing the project, threatening to kill the project. So these are all, this protected activity is listed as separate and independent examples of breaches of both the contract and the implied covenant. And under Baral, we had a right to make an anti-SLAPP motion directed at the protected activity, and Baral suggests that the proper course is for the court to go through those independent allegations of protected activity and strike them. It may be, like Baral, a mixed case where there is non-protected activity that will go forward. But by clarifying that the protected activity is improper, the city will be saved the burden and expense of attacking allegations of protected activity through another motion and having to respond to discovery about protected activity.
Why, though, if that's the case, did the city file the demur and what Justice Richmond calls, the standard motion to strike? Why were they filed and then only weeks later the SLAPP motion was filed? And actually, the way it was originally set, maybe you can cast some. Second part of my question is maybe you can clarify why it is that the SLAPP motion was set for hearing, as far as we can tell from the record, later than the other motions, but it was all kind of heard on the same day.
Yeah, just as Miller, just as Richmond indicated, my firm and I were not counsel for the city at the time the motions were filed, so I don't know their strategic decision making. I do know that they were all heard on the same day on April 25th. And I do know that the case law, such as the Martin case, say that when you have a demur together with an anti-SLAPP motion, that the proper course is to rule on the anti-SLAPP motion first, because it's directed at the original complaint, and put the demur to the side. And similarly, I think it was in one of these cases, it might have been Simlar Air Conditioning, where they amended the complaint after there was an anti-SLAPP motion and a demur, and the Court of Appeal said amending the complaint meant that they didn't have to respond to the demur, but they couldn't avoid responding to the anti-SLAPP motion, which was directed at the original complaint.
Yeah. So on the day of the hearing,
I'm sorry, Marla, before you ask your next question,
yeah.
I think for clarification purposes, I'm not sure it's accurate to say that the SLAPP motion was heard on April the 25th. I don't think that that's appropriate at all. What Judge Lee started by talking about the SLAPP motion, but it wasn't on calendar until May.
Well, that was actually my, thank you, Justice Richmond. That was actually what I was going to follow up with Mr. Finberg, because we don't have a register of actions. But when the court starts the hearing on April 25th, she says, as you know, there are 3 motions on the calendar. And from what we can tell by the pleadings that are in the appendix, the SLAPP hearing wasn't set till May the 14th. She didn't issue a tentative on the SLAPP, but had something happened? Was everybody expecting that the anti-SLAPP was going to be heard on that same day?
Yes, Justice Miller. There was a notice, and perhaps it's not in the record, that moved the hearing on the SLAPP motion to the same day as the demur and the ordinary motion to strike. And counsel were prepared to argue all 3 motions. And it was Ms. Layton from my firm who did argue all 3 motions at that hearing. So there was a hearing on the motion to strike, the demur, and the special anti-SLAPP motion at that hearing. And then Judge Lee said that her tentative was to deny it as moot, but the correct procedural path would have been for her to rule on the anti-SLAPP motion directed at the allegations of the original complaint.
And when we don't have any tentative ruling, at least not that I could find in the record. But I did notice that when the judge issued the order the day after the hearing, the first order that or a few days after, I guess it's April 28th, the first order she issues after that hearing is the SLAPP order, and obviously it's April 28th. That's well in advance of when it was originally noticed for. And that hearing says it had been that order says that the motion to strike had been set for hearing on April 25th, 2018. Well, or 19, I guess, or maybe 18. Maybe I guess it was. I'm not sure when it was. But so anyway, nobody was surprised that came up for discussion at the hearing. Is what you're saying?
That is correct, Justice Miller. I believe that OBOT wanted the proceedings to move quickly, and the city agreed to have them all heard at one time, and they were all heard on the 25th. I think Judge Lee gave an oral tentative at the hearing that she was inclined to deny the anti-SLAPP motion as moot, and there was an exchange of letters where the city indicated that that was not the proper procedure, and Judge Lee then, a few days later, did deny it without prejudice. But the proper procedure set forth in Martin, Simmons, Salma, other cases, is that the city was entitled to a ruling on the anti-SLAPP motion as to the original complaint, and consistent with Baral, the court should have gone through the mix of allegations about protected activity and non-protected activity, identified the protected activity, and stricken the protected activity, awarded the attorney's fees to the city for having brought meritorious motion regarding protected activity as to which OBOT would not be able to prevail, and then OBOT could have proceeded with a complaint, perhaps an even more narrow version of their First Amendment complaint that doesn't have the vague allegations regarding statements and briefs to the STB and the ACTC.
Well, let me just say that I know Martin says what you just quoted it for saying. I don't understand that that's the procedure that must be followed. I mean, to begin with, Martin, it's clearly dictum because they decided what they did in any event. But I guess as I go back to what I said about Judge Lee, the way she handled this makes so much sense to me, and that's where I started my questioning of you. Why rule on a case if something's going to be demurred out?
Justice Richmond, the answer is twofold. One, the city shouldn't have had to go through the burden of bringing the motion in the first place and have to have motion practice directed at protected activity, and is entitled.
Mr. Finberg, where that argument just falls down is, I know you weren't counsel, so I'm not casting any aspersions on you individually, but the fact is that the city took it upon itself to file a demur and a motion to strike. It didn't need to. It could have done the anti-SLAPP right away. So to say that the city has been burdened, they brought it on themselves in this case.
Clearly, hindsight is 20/20, Justice Miller, and in hindsight, it seems like the better practice would be to make the anti-SLAPP motion without the demur. It created a certain amount of confusion, I think, to bring both motions. But as Martin indicates, that has happened before, and courts have addressed what to do. And going back to Justice Richmond's concerns, I think the city is entitled to have allegations of protected activity that don't survive stricken so that it's not burdened with respect to either pleading practice or discovery going forward. And that motion did serve a meritorious purpose, and it satisfied both prongs under the statute. Justice Richmond, if you'd like me to address the sections of CCP 425.16 E, it's under sub 1, oral and written statements made before a judicial proceeding. That would be defending the federal lawsuit.
Where in the moving papers do they cite that?
I know that We didn't draft the moving papers, Justice Richmond. We did prepare the reply papers. I do know that they're addressed in the reply papers, and we did address them at oral argument. And sub 2 deals with statements before executive proceedings. So the STB is an executive proceeding. The public statements of city officials fall under sub 3, any written statements in a public place in connection with an issue of public interest. So I think this protected activity, the defending the federal lawsuit, the briefs filed with the STB, the mayor's letter to the ACTC, the public statements, these are all protected activity. And the city does have meritorious defenses to allegations regarding events before June 2017 under res judicata, because OBOT had previously brought a federal lawsuit seeking to stop the city from, in its view, interfering with its ability to build the terminal. So OBOT would not be able to prevail on these allegations. So both prongs of the anti-SLAPP standard.
How is that different than Judge Lee's ruling overruling the demur on res judicata?
With all due respect to Judge Lee, I think Judge Lee also erred in overruling the demur as to res judicata. That is a de novo question, and this court can address that.
Wait a minute, that's not on appeal.
Not in the context of the demur, Justice Richmond, but the issue comes up in the context of the second prong of the anti-SLAPP analysis.
And right, but first you have to get by prong 1. Let me just say, I understand, and I'm sure Justice Miller and Justice Stewart do too, why you're not backing off. We know that you didn't file the original papers on behalf of the city. And I guess you could intimate, or at least from one of my comments about those moving papers, let's just say they're not the best moving papers that I've ever seen personally. And had you not appealed, you might well have had a much, much better SLAPP motion to the amended complaint. But you chose to appeal, and you've asked us, and I'm totally on board because I don't agree with any of the cases that say the trial court hasn't reached this, so we'll send it back to reach it, and all that does is delay, prong 1 determinations for another year. So we'll reach what you asked us to reach because they agree, and we're going to do it. And now we're going to do it in the context of this motion against this complaint. That's what we're going to do. And I guess it may turn out to be that appealing and asking us to decide may not have been the wisest thing to do, but that's water over the dam.
Mr. Finberg, go ahead. Go.
Well, I just wanted to flesh out your comment. I mean, I do think that we are right on the res judicata argument, and to the extent that you don't think we are, I would like to address your concern.
Well, I guess my problem is that I'm not going to stop you from addressing anything. I don't see this complaint as being based on protected activity, certainly not to the extent of throwing the entire thing out. You admit that yourself. The case is going forward. Had the amended complaint been filed and another motion to strike, SLAPP or otherwise, been filed, maybe we'd have winnowed down something, and by now the case may have been at its last case management conference. Certainly with a pandemic, it couldn't have been to trial, but here we are. And we're dealing with the motion that was before us.
My understanding is...
Go ahead.
Prior to Barral, perhaps anti-SLAPP motions directed at complaints were requesting that the entire case be thrown out. But my understanding is that post-Barral, you can direct the anti-SLAPP motion at particular allegations of protected activity, and that if it's a mixed case, it may be that non-protected activity goes forward. And it's in that context that the motion was brought. And with respect to res judicata and collateral estoppel, OBOT brought a case in federal court in June of 2017 arising out of the same primary right. It could have included other claims, other allegations, and the fact that it chose not to doesn't prevent that from barring other claims arising out of that primary right. Justice Miller, I'm afraid I cut you off earlier. I'd be happy to answer that question.
Okay. So my question also was back to the original way that meetings were attacked. As I understand it, the motion to strike, the standard motion to strike, was granted in part. And did that have the effect of striking some of the same portions of the complaint that were the subject of your flat motion?
So, Justice Miller, first, the anti-SLAPP motion, as you pointed out earlier, had already been denied as moot before the ruling on the demur or the motion to strike. Judge Lee's ruling on the motion to strike was far narrower than what the city had requested in its motion to strike. And I think going back to paragraphs 156 and 168, Judge Lee's motion only struck a specific paragraph regarding the enactment of the illegal ordinance and resolution banning any transfer of coal. She said that was the precise topic of the federal litigation. I'm going to strike that. But she did not agree with our res judicata argument that other activity arising out of that same primary right, that the city was interfering with OBOT's right to develop the property, should also be barred. And so her motion to strike does not strike the allegations regarding permits or the STB or these other comments and activity that occurred before June of 2017. And I think, the Weichel case, where originally someone sued on behalf of a lot line agreement, and then after they lost, they sued under the underlying easement agreement, and the Supreme Court said, look, these both arise out of your primary right to want to develop the space of land between the two properties. You could have had different contracts, you could have different facts, you could have different theories, but it's all barred under res judicata because it's all part of the same primary right. And that's the argument that we made to the trial court, and we urge the justices, when you do rule on the original complaint, to strike far more broadly and deeply than Judge Lee did in her order on the motion to strike, which in our view did not go far enough. Now,
wait, are you talking about the standard motion to strike?
That's correct.
I don't understand that that's before us at all. Nobody's appealed from anything. How could we rule on that? Nobody's briefed that.
You're correct, Justice Richmond, that order on the standard motion to strike is not before you. But the same arguments are before you in the context of the city's anti-SLAPP motion directed at
Let me just, it may be smart, not smart, it may be advisable to go take a look at exactly what the city's SLAPP motion argued in its 4 pages argument, because that's what's before us, period. You've got a brief, and you're the appellate lawyer, and you guys are good. We understand that. But it's the motion that was before Judge Lee that we're reviewing on de novo review. And that's what we're looking at. And that's what we're going to rule on.
Justice Richmond, it is de novo review. And we did submit a reply brief, and there was oral argument before Judge Lee, and the transcript of that argument and our reply brief are in the record too, as are all the cases that we cite in our appellate brief on why these allegations involve protected activity, why in a mixed case it's appropriate to strike allegations of protected activity, and why the city should prevail on its res judicata and government code immunity and other defenses.
So by that argument, a defendant could come in and say, this is a SLAPP case, and have a 2-page memorandum of points and authorities, and then a better lawyer comes in and appeals and argues everything on appeal, and we're supposed to look at the appellate briefing and not the 2-page motion that was before the trial court.
Justice Richmond, in fairness, I think our reply brief on the anti-SLAPP motion and the arguments made at the hearing before Judge Lee did present the argument, so the OBOT had a full and fair opportunity to address all of the arguments, and they are there, and the court can look at the full context when ruling, not simply on the moving brief.
Mr. Finberg, was there any objection in the trial court from the other side to either the reply brief or the arguments you were making as, waived or somehow not properly presented because they weren't in the opening brief?
No, Your Honor. No, Justice Stewart. I'm sorry. There were not. So OBOT was not deprived of the opportunity to address the arguments that we made in our reply brief. There was a hearing on April 25th that addressed all the issues. I see that I have not necessarily persuaded you. I am happy to continue if you like, or if you have more questions for me, I am happy to.
I'll go back and take a look at the April 25th. I honestly don't recall it as having any argument, as you put it, on the SLAPP motion, but I'll go back and look.
Thank you. And if you don't mind, I'll save a few minutes for rebuttal. Thank you.
Fine. Mr. Schatz?
Good afternoon, Your Honors. May it please the court, Benjamin Schatz of Manat, Phelps & Phillips for the plaintiffs and the respondents, OBOT. The trial court here correctly denied the anti-SLAPP motion and granted leave to amend based on the city's own handling of this case and its own acts. And the panel has stolen my thunder. Each one of you has said exactly one of the things that I wanted to convey. And essentially that is that the city invited the denial of this anti-SLAPP motion by filing overlapping and duplicative motions, a demur, a motion to strike. All of that was done before the anti-SLAPP motion. And then perhaps as an afterthought, they thought they'd come in with yet another paper. But of course, the trial court had devoted a lot of attention and work to resolving the demur and the motion to strike. And in doing so, realized that at that point, it was plain that there was going to be an amended complaint. And so there was no point in engaging in the line item veto procedure that the city wanted to do and go through the entire complaint and pick out this, that, and the other, when it was plain that another amended complaint was going to be necessary.
Counsel, what about your Mr. Finberg's argument that, look, under the SLAPP statute, when we attack protected activity, we're entitled to fees, and by not addressing the motion at the time and letting you take a crack at amending, where you left out a lot of the stuff that they had attacked, they might have been, or maybe even likely would have not been recompensed in fees for the extra work that was occasioned by the allegations of protected activity.
So that comes up a lot in these cases. That's the tail wagging the dog. You're right that the statute has a fees provision, but there's nothing that happened in this case that would have prevented them, as Justice Richmond pointed out, from moving for fees later and going back to the judge and saying, now that we see where things are, we really did act as prevailing party on the original SLAPP motion, and so we should be given something. And frankly, it probably wouldn't be much, because when you talk about the extra work, it's the same arguments that they made in the demur and the motion to strike that are just recycled and used again in the anti-SLAPP motion. So the anti-SLAPP motion is
remedy that goes hand in hand with the SLAPP that you don't get just for winning on a demur. So anyway, but go ahead.
So to address that, our point is that it's conceivable that they could file a fees motion, and And that's, and then the trial court will do with that what she wants to do with that. You can decide, whether they really were prevailing parties entitled to any fees or not. But that's separate than an anti-SLAPP motion, which is the point that Justice Richmond raised, and that is our biggest fear, is that we don't want to be on a merry-go-round of endless SLAPP motions and endless SLAPP appeals. This is a construction case, a big one, a big project, and time is money. Many millions of dollars have already been spent and lost, and that are at stake. And every bit of delay is harming OBOT, and the city knows that. And so the city has over-litigated this. As you saw from our judicial notice request, the city's filed a new case recently, but they've already been found by the Federal District Court and the Ninth Circuit to have breached the development agreement through the illegal ordinance. So there's no question that this is a breach of contract case that eventually will get to the merits one way or another, and that's all that we're trying to do. What OBOT wants and what every plaintiff wants is to be able to move forward with its case without having to have these procedural delays. This appeal alone has taken over a year. And as Justice Richmond pointed out, it wasn't necessary because we had proffered an amended complaint. And so there were ways to deal with this. And by filing this appeal, they effected a stay and have delayed this case for a year for basically no legitimate purpose. And that's why when Judge Lee looked at it, he saw the efficiencies that would be had by saying, okay, that any sort of anti-SLAPP issue is premature now. It was plainly without prejudice, so they could come back either with a new anti-SLAPP motion or with just a fees motion to say, aha, it looks like we really did prevail in some way. And the case law does allow for that. The law offices of Ellis versus Yang is a case in which there was a remand only for fees, not for addressing, to restart the whole anti-SLAPP routine, which would then conceivably create another appeal and so forth. And so there is a way for dealing with the dangling fees issue. And I want to emphasize, there's nothing in the statute that prevents the trial judge here from doing what she did in holding that motion back. There's nothing in the Supreme Court law that says that she couldn't say it was premature and deal with it later. And doing so doesn't contravene the purposes of the statute, as Justice Stewart pointed out, and Justice Richmond, because what the trial judge was doing was helping to get rid of the offending claims, move the cases along. And again, the only missing piece is arguably fees, but that never really did go away. It was still in play. And the case law that Mr. Finberg has cited, at best, they're all Court of Appeal opinions. So they're certainly not binding on this court. And as Justice Richmond correctly pointed out, it's dicta.
Were you saying, Mr. Schatz, were you saying that I think you said Ellis v. Yang case addressed?
We lost him.
We've lost Mr. Schatz.
Oh,
There you are.
There you are. Well, you're frozen.
You're frozen, Mr. Schatz. I don't know what that.
Oh, we're all frozen.
No, we're not. You're moving. Now he's back, but he's still frozen. Maybe our clerks can communicate with the Blue Jeans people or something.
I'm waving my hand. Can you not see me?
We can't see you. Oh, now we can.
Mr. Schatz's connection is very low.
Oh, it's a connection issue.
I'm doing everything I can to get back on.
I can see you.
Am I here?
Yeah,
Yes.
we can hear you now.
Okay, I'm sorry. I don't know what happened. I was talking.
I was asking you about Ellis v. Yang and whether you were saying that that case allows the order of things that happened here to happen, or was that case relevant to an attorney's fee issue? I got a little bit lost.
I'm sorry. It's relevant for the attorney's fees point.
Okay.
It's relevant for the point that the Court of Appeal remanded. It vacated a denial of an anti-SLAPP motion simply so that fees could be addressed. That was, and that was my point. But the fees issue doesn't go.
Is there case law on the other side of the case that has the dictum that Justice Richmond referred to, Martin or whatever it was? Is there case law going the other way? Is there a split?
I wouldn't say there's a split. I would say that there is some dicta where sometimes the Court of Appeal will say it would have been better if the trial judge had ordered the motions in this particular way. But in none of those cases do we have the situation we have here, where a defendant comes back with a demur and a motion to strike, and then later says, oh, and I guess we'll throw in an anti-SLAPP motion too. And none of the cases say that it would be wrong for the trial judge to address motions in the order in which they were presented or in the order that most logically and efficiently would handle the cases.
Well, I'm assuming it may have to do with just the deadlines for demurs and motions to strike, and I don't know. I haven't really thought too much about it, but perhaps they filed the demur when they had to file it and then filed the SLAPP motion within the time that they had to do that.
But, you know, if a party really thinks that SLAPP is the right response to a complaint, they can just file a SLAPP motion. And if timing is a problem, they can try to get it heard expeditiously in some way. But that's not really what was going on here. And that's not, of course, how this case is being defended. The case is being defended with the perspective of delay every single day until they can try to destroy this project and cause as much trouble for the plaintiffs as possible. And so,
where's that in the record, Mr. Schatz?
That's in our opening brief. That's our theme, but I think the record does bear that out if you look at it. And all of the side litigation that's been going on, which is why we unfortunately burden the court with various requests for judicial notice so that you could see the overall aspects of what's happening with this litigation. And we wholeheartedly can.
What is the reason you requested yesterday we judicially notice the brand new complaint? I don't. Why should we do that?
It was just to show how the city is handling this litigation, because that brand new complaint, that should just be cross claims in this litigation. It doesn't need to be another motion. And so it goes to our thematic point merely that the city is throwing the kitchen sink and everything it can come up with at any time to try to delay, this case and make it more complicated than it ever needs to be.
Well, that's asking a lot, Mr. Schatz, because frankly, perhaps they didn't feel they could file it for the same reason you couldn't file your amended complaint, which is there's a stay affected by the motion and the appeal. And they did give notice to the court, and we're not going to look at the merits of it to decide at this juncture whether it's got any there or is just, as you put it, to complicate things. That would be a real an ask that we couldn't answer, I guess.
Well, it's purely for background purposes, and I appreciate the Gertrude Stein quote. I mean, there is there in the plaintiff's complaint. We've got that from what happened in federal court, and we've got that from things that have happened after the federal litigation, which is the broader focus of this particular complaint. It all comes back to what's happened most recently. And all of the different things that the city has done. The city tried to derail this completely, pardon the pun, with the ordinance, and that didn't work. But they've done all kinds of other things with the permits, and I mean, you've seen the complaint. You know that if the city decides it wants to throw roadblocks at you, it can do it in many, many, many different ways. But ultimately, this case is about that bad faith, that breach of contract, and not about any of the particular things. Oh, the city sent this notice. And they say, oh, well, but that's protected speech. It's not really about any of the particular things that's happening. It's all of the things that the city is doing together to try to weasel out from under the contract that it's decided that it doesn't want to abide by. And the contracts contain obligations for the city to cooperate and to try to get funding and to do many things, which they're not doing. They're refusing to do. They've repudiated. That's what this latest complaint is. It relates to that. So that's how it all fits together. That's the big picture. And the big picture is important because the policy concerns of the anti-SLAPP law would not be served here by continued delay and continued appeals and forcing the trial judge to have to go line by line through a big complaint that is admittedly superseded. There's going to be a new complaint. And to cry foul over the fees isn't good enough, and the case law doesn't go far enough for them to get what they want in the way they want it now. And unless there are any other questions, I think you understand our position.
I think there are none. Thank you, Mr. Finberg.
Few brief point, Justices. One, I am informed that on March 4, the trial court reset the hearing for the anti-SLAPP motion for April 25th. It apparently wasn't a formal order, and that's why it wasn't included in the record. But all three motions were heard on April 25th per order of the court. I'm also informed that the opening brief did cite the provisions of CCP 425.16E. One example of that is page 10, line 16. So OBOT was on notice of what provisions were an issue, even in the opening papers. In terms of what is binding on this court, the Baral versus Schmidt decision is a decision of the California Supreme Court, and that makes clear that a case like this, that is a mixed case with some allegations that involve protected activity and some that are not, that the proper procedure on an anti-SLAPP motion is to go through each allegation of protected activity that is alleged to be the basis for the claims, and everything in 156 and 168 is, and to go through them one by one and to say whether or not they're protected activity and whether or not the defendant would prevail on those. And so we urge the court to do that and to strike the protected activity, particularly if this court finds that our res judicata defense under primary right is a valid one, which it is. And as to the other defenses, Judge Lee actually agreed with us on the other counts 4 through 10 and dismissed them for statute of limitations, government code, etc. And as to
when you say dismissed them, she sustained the demur with leave to amend.
That's correct, Justice Richmond.
Well,
but she did.
Them.
She found error, defects in them. Let's put it that way, Justice Richmond. And Justice Stewart, you're absolutely right that the thinking of the city was that the OBOT versus Oakland case in state court was stayed, and that the city does want to resolve this dispute. And the city, it should be noted, did stipulate before this court that this appeal could be heard expeditiously, so that the stay could be lifted earlier. So,
but the litigation was stayed because of this appeal, something that the city had complete control over. Going back to the question of how did we get to be here?
That is true that it was stayed pursuant to this appeal, but by filing a breach of contract action separately, and OBOT could file a counterclaim in that case, the city opened a venue for resolving this dispute promptly, which is what the city wants to do. Thank you.
That last part just doesn't quite square with, now I've changed my view from the beginning, it doesn't quite square with taking the appeal from this anti-SLAPP, but I'll stop there.
Well, Justice Miller, I would only say the city did feel strongly that the original complaint was not proper, that it did have allegations of protected activity, and that they shouldn't have been there. And it did want this court to resolve those issues. It felt like it had an important right that should be recognized by this court. That is separate from the question. The implication of that was that the trial court stayed the case. But it does want this dispute resolved, which is why it did file this separate action.
Okay, thank you.
Okay, thank you, Mr. Finberg. Thank you, Mr. Schatz. The case is submitted.
Justice Richmond, could we take a 2-minute break before the next case?
Sure thing.
Thank you.